This is an actual discovery dispute. This is from a published decision, and unfortunately I didn't bring it with me, so I can't tell you the name of it right now. But the judge was very perturbed about the lawyer's inability to get along and inability to agree to things. So he issued an order inviting them to a kindergarten party and said the party will feature many exciting and informative lessons, including how to telephone and communicate with a lawyer, how to enter into reasonable agreements about deposition dates, how to limit depositions to reasonable subject matter, why it is neither cute nor clever to attempt to quash a subpoena for technical failures of service when notice is reasonably given, and an advanced seminar on not wasting the time of a busy federal judge and his staff because you are unable to practice law at the level of a first-year law student. Seriously, this is an actual order. And the order goes on to instruct them to bring with them their toothbrush and pajamas, just in case. Okay, Ellie, if you could start this clip. This is an example of uncivil conduct during a deposition, and hopefully the sound will work so that you can hear it.
Thanks for telling me the friend I should ask. You will have your opportunity. Just shut up when you know your question. Okay, Mr. Curry. Just shut up, or I'll adjourn this deposition, and you can tell it to the judge. I'll get you some tissues you can cry. Mr. Curry. All right? Please don't tell me what to do. You asked him if he ever spoke with Farsh about anything. He said no. Now you're asking him to tell you what Farsh told him. It is a bullshit question. It is absolutely speculative, no foundation, or anything else. Now, he's entitled to a fair question. You told him that. So if you're going to sit there and ask unfair questions, I'm going to correct you. So I don't waste this guy's time having to come back or go to trial and undo the mess that you're trying to create. Got me? Are you finished? Are you finished? Do you understand the question?
Are you aware of the local rules with regard to what objections you are allowed to make and what
Do you understand the question, Mr. Foster?
Sir, right now this is my witness. I get to ask the questions. You get to make objections only. There are two types of objections you can make.
Call the bell.
Sir,
Do you understand the question being asked?
just hurry.
Don't ever presume that you get to tell me what to do or when to do it. Don't you ever presume. Mr. Foster, this is your deposition. Do you understand the question?
Why should you be entitled to then tell me what to do? Doesn't it go both ways?
Because I'm being straight with the guy, and you're being not straight with the guy. That's why. He has no dog in this fight.
Are you finished giving your opinions now about
He has no dog in this fight, and you're trying to get him to say things that are simply untrue. It's an old trick, Mr. Zolmar.
You don't think you're trying to coach the witness right now?
I'm telling him what the question is so he can answer it.
Do you know what the speaking objections are?
Don't lecture me, idiot. I'm telling you I'm not gonna let that happen. Okay? You got me? Do we understand each other? Are we connecting here? Because if we're not connecting here, I will try again. Okay? Don't give me local rules, don't give me procedures, don't give me professionalism. Just put a fair question to the witness. And if you're not going to do that, then I am. You understand each other?
If you believe that a question that I asked is not proper, then you get to pose a valid objection. You're not allowed to make speaking objections, you're not allowed to do...
Don't lecture me, puppy. Don't lecture me. I was doing this and you were still chasing cheerleaders. Don't you even think about lecturing me about depositions.
I think the prosecutor has more than me.
So, do you understand the question?
Mr. Curry,
Let that question.
follow the rules. If you don't believe we should be following the rules, then maybe you need to explain to me what procedure you are supposed to follow.
Believe it or not, this is on YouTube. So this lawyer has gone down in history, and you can Google lawyers behave. If you go on YouTube and put in lawyers behaving badly, you get a number of really interesting things. This poor guy, I don't know if he got to answer one question in his deposition. Although I have to say, just to point out here, the one lawyer, Mr. Farsi, I guess his name is, I think handled the obnoxious lawyer pretty well. He didn't respond in kind. He didn't raise his voice. He didn't get too excited. He tried the best he could to try to get the deposition back on track. But sometimes it's really difficult. Now, I'm going to skip this clip because it's just it's pretty entertaining, but since we started a little bit late in the interest of moving things along, I'm going to skip it. This is a really short clip. There is no sound with this one. Just a little bit of a setup. I'm sure that George will recognize the decal on the floor. This is actually near the elevator bays in the Maricopa County Superior Court. And this is surveillance camera footage. Unfortunately, I threw this in here because this involved an assistant attorney general. And this is an example of not letting personalities get in the way of what you're doing. You're going to see two lawyers coming out of those doors after a hearing. It was a motion hearing, and one of the lawyers made some comments during his argument that the other lawyer took umbrage to and felt it was impugning his integrity and his professionalism. These lawyers have a history, unfortunately. Go ahead, Ellie. And the reason that we have this, here they are coming out. The guy with the cane is the assistant attorney general. The other guy used to be an assistant attorney general. So they're sort of shaking their fingers at each other, and there's a pushing and shoving match. And essentially, the assistant attorney general is telling the other guy, if you ever do that to me again, I'm going to report you to the bar. And the other guy is saying, I'm going to report you to the bar. And this situation, in fact, did result in dueling bar complaints. The assistant attorney general filed a bar complaint. The other lawyer filed a bar complaint. Their version of what is going on in this footage was remarkably different, because the guy with the cane said, he pushed me, I could have fallen down and been seriously injured. And then the shorter guy said, well, he hit me with his folder, and they actually filed a criminal complaint. Nothing came of the bar complaints, nothing came of the criminal complaints, but it's just an example of don't let personalities get in the way. And scheduling dispute, this I think is my last example. This comes again from a published order. There was a case going to trial. The lawyers were in Kansas City. The trial was going to take place in Dallas. And one of the defense lawyers requested a 2-week continuance of the trial date because his wife was imminently going to give birth to their first child. And believe it or not, the plaintiff's counsel opposed the request for continuance on several bases. First of all, that the lawyer had to know ahead of time when this child was due and could have taken it into account at the time they were setting the trial date. Also argued that the defense had 5 lawyers, and surely they had enough coverage. Of course, the judge pointed out that the plaintiffs had multiple lawyers on their side also. And then the one that really I thought was hilarious was they attached to their opposition to the continuance request a copy of the flight schedules between Kansas City and Dallas, arguing that certainly he would have time to catch a plane if his wife went into labor while they were in the midst of trial. Judge really was not happy and said, certainly this judge is convinced of the importance of federal court, but has always tried not to confuse what he does with who he is, nor to distort the priorities of his day job with his life's role. Counsel are encouraged to order their priorities similarly. And he granted the continuance and congratulated defense counsel on the impending birth. You need to be reasonable when a request for continuance is made. So now let's talk about some of the ethics rules that require civility. When you go through the rules, there's actually quite a few places in the rules that talk about topics related to civility. I don't know how many of you are familiar with the preamble to the Rules of Professional Conduct. I'm kind of an ethics geek, so I've read it many times. And there's several places in the preamble that refer to things that constitute civility. Paragraph 5, a lawyer should use the law's procedures only for legitimate purposes and not to harass or intimidate. A lawyer should demonstrate respect for the legal system and for those that serve it, including judges, other lawyers, and public officials. In paragraph 7, lawyers should strive to attain the highest level of skill to improve the law in the legal profession. That should say profession, not professional, and to exemplify the legal profession's ideals of public service. I threw that one in since we're all public servants. A lawyer is obligated to zealously protect and pursue a client's legitimate interests within the bounds of the law while maintaining a professional, courteous, and civil attitude towards all persons involved in the legal system. I think this is the one place that the word zealous is still in Arizona's rules, and I think New Mexico's.